Hello, it's Phillip Taylor speaking from Richmond Green Chambers. I'm looking at a book from LexisNexis. This is The Law of Damages. It's in the Butterworths Common Law series. You can see it mentioned on the spine. It's The Law of Damages, second edition. It's under the general editorship of Professor Andrew Tettenborn, and this particular edition is edited by David Wilby, Queen's Counsel. Now, my wife Elizabeth and I have written a review, which is a fairly detailed one on Flickr. And the written review will appear in some detail, obviously on the internet. What we've got here, though, is a book which sets out in the normal traditional way of having paragraph numbering, and you've got a lot of footnotes and various other things at the bottom. You've got a very good index at the back, and obviously standard cases right at the front. What is of interest are some of the comments that are made, because the one thing I've found helpful about this is that when you're looking at a particular area, you've got a commentary here which assists us, I think, greatly as advocates, and it also assists the bench, because that's what we're going to find when we go into the courtroom. The odds are that this book will be here. Not to say that the other books that compete with this are any better or worse, but this is the one, I think, which the judges will actually prefer. Now, the title we've given this review is the best book for the bench on damages, and what we've said, general terms, is that issues with respect to damages concern money, from how much a claimant might gain if successful to how much he might lose if he isn't, working under our original rigid common law remedy of monetary payment as the first stop to sort things out. This is a big book in every way, as I've said, and there's much detail which many may feel they don't need in the smaller firms. I think you probably will do, because this is what you're going to need if you're going to think how the judges think about what they're going to do. So both Tettenborn and Wilby have blended practical guidance, paragraph by paragraph, with the academic and the judicial approaches to achieve the best advice which judges and advocates need in the courtroom when the real decisions are being made. Obviously, and they need to advise accordingly. Now, all this may sound perfectly straightforward, but as every lawyer knows, damage cases can be extraordinarily complex, not to mention emotionally fraught, especially in the common law jurisdictions where such cases raise issues of law, and therefore the editor's observations that in damage cases appeal courts pronounce on questions of principle to an extent astonishing to our European observer is actually an important point to bear in mind. I think, of course, that this book amply provides us with the positioning of it as something we would see on the judicial bench during proceedings, and therefore we would have to be aware of the advice that's given in the paragraphs. The intention, of course, behind all of this is that it's quite indispensable as a work, and it provides authoritative but user-friendly coverage of the whole area of the law of damages in both contract and tort. It's about 1,000 pages long, and it's quite bulky, but it gives a full range of the issues that are covered. The structure of the book itself is commendably straightforward, beginning with general principles and then dealing with damages for individual wrongs, and then for breaches of particular common types of contract. I think I can say, as a barrister at law, certainly it's a professional practitioner's book of the moment in this field, and one of the leading works. Research resources are copious, with at least 20 pages of the table of cases which I showed at the front, plus a 67-page index at the back. It's reassuringly detailed, and it's also useful for fast, easy reference, especially with the comments that are made. And I think almost certainly it's something you should have in your law library. Damages, of course, are an area of law which have become pivotal within most legal practices, hence the need for this sort of work. It's a complement, of course, to the more established McGregor and Kemp, but it's, I wouldn't say, a direct competitor in that sense, because we look at them for different things. So the editors really have asked the questions going through our minds towards the conclusion of each of the cases in the well-constructed paragraphs. It's the sort of question that we would be asking ourselves to advise our clients. So it gives, in our view, the best book for the bench on damages which is currently around. Thank you very much to the writers and to LexisNexis. Bye-bye.